Supreme Court First Department. He, all persons having business with the Appellate Division. Draw near, give your attendance, and you shall be heard. Please be seated.
Oh, there's nobody here. Good afternoon, everyone. Welcome back. Welcome to the Appellate Division First Department. So, as you all have been here probably before, there's no real need for me to go into the normal spiel. However, according to this, there are 7 hours of argument time requested. So obviously that's not going to happen. Please, only to request the time that you actually need. Also, as you probably know, we've kind of changed some of the modifications for COVID. So during your actual oral argument, if you wish, you may remove your mask for purposes of the argument, okay? When you are actually arguing, not when you're sitting there, when you're actually arguing. And when you're seated now, please keep your mask on, okay? So as I stated, please, only request the time that you actually need for your argument. Please keep in mind that we have read your briefs. We spent the entire summer reading your briefs, so we are fully familiar with your arguments, probably more so than you are. So, keeping that in mind, People v. John Heater. Excellent, submitted. RS 201962 versus 143 East 62nd. Submitted. E. Brigitte versus Lissandro. Submitted. Retail Consulting versus Fitness Recovery. I'm sorry, requesting A+2? I'm sorry, yes, sir. 15? I'm sorry, did you say 15? Okay, thank you. So 6 and 2 and 6. Cordero versus Advantage Care Physicians.
Justin Heller for the appellant, 5 and 2. Jared Hayden for the defendant respondent, 7 minutes.
5, 2, and 5. Ampin versus 160 East 48th Street.
Motion to request 6 minutes and 3 minutes for reply. Longer probably for respondent, Your Honor, 7 minutes for reply.
6 and 2 and 6. People versus Dramaine Colbe. That is submitted. Syringa House, I apologize, versus City of New York.
Respondent, Your Honor, 4 minutes, please.
So there's no appellant. You still wish to argue?
How about maybe 3 minutes?
No, 2.
Okay, thank you. Fair enough.
Ware versus Montefiore.
Emily Hagan on behalf of respondents, Your Honor.
Now, the appellant did notify the court asking for time to argue, and I stated that at the call of the calendar, we would make that determination. So he is pro se. So let me call it last, and we'll see if he appears by then.
Thank you, Your Honor.
You're quite welcome. Yoakum versus U.S. Tennis Association.
Frederick Roberts, on behalf of the respondents, 6 minutes.
5, 2, and 5. Annie versus Amon. That is submitted. People versus Sandro Schweizer. Submitted. People versus Ronald Wright. Submitted. Heldman versus Kalahari Resorts. 2 minutes. 1812 Lacoma Avenue versus New Rays LLC. Yes, submitted. Thank you. People versus Murray Brooks. That is submitted. Lyons versus New York City Transit Authority.
For the appellant, 6-2, Your Honor.
6, 2, and 5. People v. Fernando Rosario.
Appellate requests 6 minutes and 2 for rebuttal.
6, 2, and 5. Gin versus Herman. Three. Thank you. Liberty Mutual versus Valera. That is submitted. People versus Diaz. Submitted. Bardwell versus Bardwell. That is submitted as well. And we're back to Ware versus Montefiore Medical. You want to submit? I'm sorry?
On behalf of respondents, Your Honor.
Yes, did you wish to submit now since your appellant's not here?
I'd love to have 2 minutes, Your Honor.
Okay. 2 minutes. The first case for argument is Retail Consulting versus Fitness Recovery. You may proceed.
May it please the court, I'm Stuart Reback from Wilk Oslander LLP, and I represent the appellant RCS. This appeal can be summarized in 2 short phrases. The first, what were they doing? The respondents never explained what their words and actions could possibly have meant other than what RCS reasonably understood, which is that the respondents, one way or another, took on the role of RCS's contractual counterparty, promised to pay RCS's bills, and demanded services from
Counsel, can I interrupt? Justice Schechter found that your allegations that the non-FRH defendants' agreement was uniquely in those defendants' possession was, quote unquote, inherently incredible. Would you respond to that?
Yes, that's, the short answer is that's not what we said. That particular portion that she's referring to is a mention of the statute of frauds where it says that confirmatory writings, additional confirmatory writings are in their possession. We make extensive allegations, some including references to particular emails that are in the record, which are referenced on pages 11 to 13 of our brief, as well as, I believe, page 8 of the reply brief, references to specific emails where, and I'll just run through this very quickly. More, paragraph 40 of the proposed second amended complaint acknowledges an obligation to pay, asking for more time to pay, which appears in paragraphs 38, 41, and 44 on pages 758 to 759 of the record, asking for a W-9, paragraph 42, promising to make a partial payment in paragraphs 38 and 42. How could RCS have understood these as anything other than an acknowledgement of an obligation to pay RCS's bill? We pointed out we have about 10 pages of our brief and pages 17 to 26 of our brief going into minute detail of exactly what Justice Schechter got wrong, almost paragraph by paragraph, pointing out what she missed, what she overlooked.
So, but you do have to have a writing, correct, if you're going to adopt the debt of another under the statute of frauds?
Yes.
And so are you saying that the emails that are illuminated or discussed in your complaint are sufficient to create that writing?
We think they could be, but they certainly are indicative of the existence of an agreement. You see, one of the things that they got wrong was they're confusing contract formation with compliance with the statute of frauds. So contract formation can be done with or without a writing, or with some writings and some oral statements, but to comply with the statute of frauds, you have to have confirmatory writings that get produced. Under WPP and Silver v. Silver, those can come from, even if the plaintiff didn't have a stitch of writing, which is not the case here, we have writings. Even if the plaintiff didn't have a stitch of writing, statute of frauds compliance could come entirely out of the defendant's own files. That's what those cases say. And the writings don't have to be writings that constitute the agreement. If you look at the Ladenburg case, which he cited, I believe page 17 of the reply, they merely have to be confirmatory of the existence of the agreement and together either expressly or by implication, spelling out the terms of what the agreement is.
Counsel, are you arguing that the writings as they exist are sufficient to satisfy the statute of frauds, or that there's enough there to allow you to conduct further discovery?
If we were at summary judgment, then I think we would have an argument about what inferences are to be drawn, but we're not at summary judgment. We've alleged both oral conversations and various writings that together indicate that there was an agreement, either a new agreement or that the respondents had assumed the obligations under the pre-existing FRH agreement. Remember, they were acting like contractual counterparties from day one. On December 9th, 2020, when my client sent to Pete Moore, who was designated as the agent for the respondents on that fateful conference call that's alleged in paragraph 35 of the SAC, when he sent them the bill, the response was not, why are you sending me this? What is this? We don't want anything to do with this. The response was, let's go over this, and I have a slot to pay you in December.
Let me just interrupt for a minute, because I want to ask a question before we run out of time.
Yes.
You also had an implied contract claim. If in your amended complaint, you're taking the position that there's an actual agreement or assumption, are you willing to concede at this time that if that's true, that you no longer have an implied contract, or you're trying to still make that argument?
Well, if there's an argument that the actual express statements were not enough, then after there's no longer an existing written agreement, which by its terms terminated, it was over by the time the respondents appeared on the scene. Remember, that agreement terminated
Counsel, is that your claim, that there was an abandonment or termination of the deal with FRH? I mean, is that the claim? I understand you're taking alternative positions, but what precisely is your claim?
No, we say it did terminate.
So you do say it's terminated,
It did,
and therefore...
it terminated. And one of two things happened to it. Either it was assumed by the respondents so that by the time we met them, they were already the counterparties, which they certainly acted like that was the case, or based on our interactions with them afterwards, that was a new agreement. And the facts are consistent with either theory.
Thank you.
Thank you.
Good afternoon, Your Honor. Jeffrey Chupak of Meany LLC for the respondents. As the court's aware, RCS entered into agreement with FRH for lease negotiation services. FRH is now bankrupt, and RCS is now looking for someone else to pay its fee. But RCS can't point to a single writing actually satisfying the requirement.
Well, but what kind of writings, sir, need to be shown at this point? Wouldn't it be sufficient to show emails, allege that there may be other emails or other writings in your possession which support the arguments being raised here on this appeal?
If in fact the emails pointed to whether as an attachment to an affirmation in support of the motion to dismiss.
But this is a motion, but there's a motion to amend, and so that's what we're focusing on now.
So if any of the emails actually...
So in other words, without the emails attached, it would be insufficient?
I'm not disputing that allegations could be made as to the existence of a written agreement, but if RCS's claim is premised on a writing in its possession, it should be able to describe that writing or...
But isn't what plaintiff claiming is that there were a series of writings, there was a series of conversations about it continuing doing the work it was doing for the non-FRH defendants?
If you look at the actual set of communications pointed to, I think a review of those would show that there was no promise of payment. And
So in your argument, what therefore do those emails illustrate, if anything?
There are several emails. Can I go through?
No, I don't want you to go through each and every email. So you're stating that they,
Well, the gravamen of the email pointed to is that the CFO, the gravamen of RCS's argument is that New TSI's CFO confirmed a payment obligation. That is, in practical terms, what it is saying. And the email reference is on pages 712 and 711 of the record, and those emails are themselves mischaracterized. The emails state, it begins with what appears to be a phishing email, not referencing the FRH agreement that simply states our banking information has changed, we'll provide you with new bank details for all due payments and future transactions, and then asking, will payment be going out this week? New TSI's CEO, Roger Moore, referred the inquiry to the CFO. He says, our CFO, Nitin Ajmera, will be able to provide you with an update on upcoming payments.
Counsel, aren't there specific emails, though, where there's clearly a representation being made that NUCO, not FRH, would actually pay plaintiff for the work? And isn't that enough to at least be a basis to support a motion to amend, which is not a very high standard?
So there are two, there's an email and there's an allegation pointed to, and I'll address both. The email is Nitin Ajmera's response, the CFO's response to the CEO's email. And he writes back to state, RCS hadn't been set up as a vendor in New TSI's payment system. It needs bank details in a Form W-9 to do so. And he also asks, is there a payment schedule that we can use to make your payments? He's asking if there's a payment schedule. He's not confirming an agreement.
Well, why is he asking that if he has no intention of paying?
He doesn't know. He's not even a member of the group identified in paragraph 35.
So isn't there, Counselor, isn't the obvious answer, frankly, is discovery? And at a deposition, those questions could be asked in terms of why he was writing that email, what he thought, what his understandings were, as opposed to saying, at this juncture, it's patently insufficient.
But at the pleading stage, or on a motion for leave to amend, the burden is on RCS to plead some form of statute of frauds compliant agreement. And the conclusory allegations that, oh, there was an agreement, that's what the IAS appropriately found inherently incredible.
What is incredible about it, though? Why would it be incredible?
Because the subject email communications are in its possession. It filed several hundred pages of documents in opposition to the motion to dismiss, and not a one of them is actually a confirmatory writing, which is what its claim is based on. Instead, the CFO said, the operative line is, I believe there was a deferred payment agreement, question mark. He is asking the question. He is looking to RCS to advise what actually transpired between other people.
Isn't it clear that work continued to be performed even after it was clear that the primary signatory was no longer pursuing the agreement, that the plaintiff kept performing work?
That is the allegation.
And isn't there some evidence of that?
Sure, but there's no payment agreement.
So in other words, work was encouraged by the non-FRH defendants, but no reason to pay, no implied contract. Is that your position?
This is an agreement that's subject to the statute of frauds. There needs to be some allegation of a statute of frauds compliant agreement. The gravamen of the claim is that there are confirmatory writings, and our position is that there is none. Furthermore, Tacit was never even part of the consortium identified in paragraph 35. There are several defendants as to which there is absolutely no basis for any claim.
thank you.
I'm not going to belabor matters. I'll just point out that the communications from Mr. Ajmera in January were preceded by a promise during December. I can get you $500,000 by month's end. that same email that he's talking about, Ejmer asked for a W-9 so we can set you up as a vendor. Moore and Cleaton. Cleaton, by the way, who's the head of Peak and LePerc and was in charge of the deal, said during late December, and I believe that's paragraph 41 of the SAC, told RCS, I have only $5 million right now to allocate, so I'm going to ask you for payment terms so we can pay over time. Now, asking for payment terms, I don't think is understandable by any reasonable person as anything other than, yes, we are going to pay you, and yes, we know it's overdue, but we're going to pay you over time, and is that okay? If there are no other questions, that's all I have. Thank you.
Thank you, Counselor. Thank you both. Cordero versus Advantage Care Physicians. Whenever you're ready.
Thank you, Your Honor. May it please the Court, Justin Heller on behalf of the appellants. This case is distinguishable from this Court's recent case in Riggs v. Brooklyn Hospital Center because in Riggs, the policyholder was his own policy administrator, and the only relationship between the parties was that between an employer and an employee. And in fact, that employment relationship had ended a few years before the Milmick demutualization. In addition, the policyholder in that case had signed an assignment agreement by which he assigned all of his rights in the Milmick consideration to the employer.
So in this case, counsel, I think we've read Riggs and we understand the distinctions. So in this case, the fact that the defendant is plaintiff's agent, how does that change the analysis?
I think in a very material way in this case, Your Honor, because when the employer was appointed policy administrator under the policy administrator designation form, it became the agent for the policyholders with respect to the administration of the Milmick policy, including receiving legal notices. And under principles of agency law, an agent owes a fiduciary duty to the principal. And that, to me, is the key difference between the two cases, between Riggs and this case. And when an agent's interests are in conflict with its principal's interests, it has a duty of full and complete disclosure to its principal, and anything short of that is a breach of that duty. And significantly, in this case, the Milmick sent the policyholder information statement, which Milmick intended for policyholders to receive, to tell them everything they needed to know about the demutualization and their rights to cash consideration. But it sent that to the policy administrator because it was the policy administrator. So it sent it as on behalf of the policyholders. But the policy
Certainly
administrator—
your clients didn't have to sign the consent forms. They could have gone on to the various websites, for example, and seen, in fact, how the process was going to work, right?
They could have, but it's our view, Your Honor, that when the policy administrator has that policyholder information statement in its possession that's intended for the policyholders, and instead of forwarding that, it withholds it, and instead it sends that consent form with instructions that the policyholders are required to sign and return it, because the policy administrator is the fiduciary, is the agent of those policyholders, they were entitled to rely on the instructions of their policy administrator. Could they have read that consent form thoroughly and done their own due diligence? Yes, but I don't believe that the principles of fiduciary duties require that. I think they're permitted to rely on the instructions of their policy administrator. And I think that's the key difference here. Thank you.
Good afternoon. Jared Kagan of Debevoise and Plimpton on behalf of the defendant respondent.
So, Counselor, do you take issue with the characterization here that there is, at least for the purposes of this motion, to dismiss a fiduciary relationship between the parties?
There is absolutely not a fiduciary relationship.
Is your client an agent, designated agent in the various documents?
The client is designated as a quote-unquote agent for a limited purpose, and the designation of an agent doesn't automatically transform my client into a fiduciary.
But again, we're at motion to dismiss stage, correct?
That's correct, but based on the facts alleged and the documents that are before the court can easily conclude that the designation of agent does not do anything here. And that is...
So then what was the point of the insurance company sending all the information to the policy administrator?
This was an arm's length transaction or contractual agreement between an employer and employee in which the employer agreed to provide medical malpractice insurance to the employee.
Counsel, the law is well established now, though, that but for this consent form, your client would not have any right to these proceeds. The only reason it has the right to the proceeds is because it got the employers to sign the consent form. Why, in its role as a policy administrator, wasn't it at a minimum have a duty to disclose all information it obtained in that role, which would give the actual policyholders a full disclosure of what their rights were, as opposed to what appears to be, or is alleged to be, an actual misrepresentation as to how these proceeds were to be distributed?
I would commend Your Honor to the actual documentation, the policy administrator documentation that lays out the responsibilities that our client has. And the plaintiff's appellants identified that in their opening brief.
Right, and it says the policy administrator is the agent of all insureds herein for the paying of premiums, requesting changes in the policy, including cancellation thereof, receiving dividends, and any return premiums.
That's correct. And what that is, that's to facilitate the arm's length transaction to provide the plaintiffs with medical malpractice insurance. Notably, plaintiffs' argument in their reply hinges on an additional responsibility that they've created out of whole cloth. On page 7 of their reply, they say, quote, one of ACP's functions was to receive all MILMIC notices on appellant's behalf. That language is found nowhere in the designation.
Counsel, I don't feel like you've answered my question, which is why, as its role as a policy administrator, it got certain information about the policy and the proceeds. Didn't it, at a minimum, have an obligation as the administrator to truthfully disclose to the actual policy holders what the facts were about the actual distribution of the proceeds?
Our client provided the notifications to the plaintiffs. It provided a form, the MILMIC notification, which we cite in our brief. It tells the plaintiffs that they can go to the MILMIC website to get additional information.
What did your client say with respect to the consent form?
What did the client say with respect to the consent
Your client,
form?
what did your client say with respect to the consent forms, whether they needed to be signed or not signed?
The client said that in order to have, our client said that in order for the money to be provided to the policy administrator.
If you do not sign and return the form on a timely basis and the distributions are paid to you directly, you will need to then forward that amount to defendant.
Yeah, I don't have the language in front of me.
That's what it says.
Right, I trust that Your Honor is reading it correctly. The key question, though, if there
I
is...
think so.
If there,
I've been reading for a while now. It's weird.
yes. But the key question is, if there is no fiduciary duty, that is irrelevant for the purpose of this motion. We obviously have arguments that this was not misleading. The court does not need to resolve that now because, as Your Honors questioned my adversary, the plaintiffs could have gone and got the information themselves. Therefore, there's no reasonable
But doesn't that turn on whether or not there's a fiduciary duty? And for the purpose of this motion, the language that has been cited by colleagues, isn't that sufficient for the purposes of this motion only to say at this point, we can say that there may be a fiduciary duty and move forward with the case?
Respectfully, Your Honor, the answer is no, and that goes to Northeast General Corp. Of the New York Court of Appeals. The court said in that case that what you need to look at is the relationship between the parties and the actual language. And that's all on the face of the complaint and the documents that go along with it. On the face of the complaint, there's an employer-employee relationship. On the face of the document, our client took on a role for a limited purpose to facilitate the provision of medical malpractice insurance.
Your client took on the role to be an agent with respect to the insurance. Isn't that another way of looking at it in a broader way? I understand you're trying to limit it.
It's not, because as the Court of Appeal said in Hines versus Columbia, you're looking at two different things. On one hand, there's the administration of the policy, and on the other hand, there's this ownership interest, which the Court of Appeals in Hines said is, quote, an incident of the structure of the mutual insurance policies. And the Court of Appeals further said in Hines that the designation as a policy administrator, quote, merely authorizes the employer to undertake various tasks on behalf of the employee policyholder. The fact that tasks were undertaken does not give rise to a fiduciary relationship.
It doesn't simply involve ministerial tasks. Didn't it involve the power to affect the legal relationship between the party?
It did not affect...
Isn't that a distinguishing factor from this case, from the Northeast case that you referred to?
It did not affect the power to affect legal relationship. In fact, the document itself, the designation form that the plaintiff signed, it said that the plaintiff and Advantage Chair, the policy administrator, had the right to keep the policy or to cancel it. That's in the language itself. The only purpose of this designation was for our client to fulfill its contractual obligation to provide medical malpractice insurance, that is, to keep the policy in place and to pay the premiums. The incidental ownership structure, that came along with it, did not carry or bring along with it any fiduciary duties.
Thank you so much.
Thank you, Your Honor.
I would just, excuse me.
So, counsel, I'm reading the form, policy administrator is the agent of all insurers, paying a premium, requesting changes in the policy, including cancellation, as a little bit more than what your adversary just argued. It seems that there is some type of a legal undertaking, some type of legal obligation.
That was the point I was going to make, was that I think unquestionably that language gives the policy administrator the authority to affect the legal rights of its policyholders. And I would just add as a footnote that if you read down to the notice provision of that form, paragraph 3 says the address of the policy administrator becomes the address to which all legal notices will be sent. I think I heard my adversary say that language was not contained in the form. But
the address of the policy administrator becomes the address to which all legal notices will be sent.
Yes. Thank you.
Thank you. Ampim versus 160 East 48th Street. Yes, counsel, you may proceed.
Good afternoon. May it please the court. Richard Altman for appellant Adam Weinstein. We believe here that the lower court erred by placing undue stress on reliance on the Regina Metro case and the Housing Stability and Tenant Protection Act, both of which postdated the bringing of this case in 2017. The Regina Metro case merely said that the provision extending a landlord's overcharge liability from 4 years to 6 was not retroactive. That doesn't apply here because we never have asked for anything but 4 years. Furthermore, the Regina Metro case did not, as the lower court.
Counsel, apart from the law, the facts in this case, don't they create an issue of tribal fact given that Mrs. Shapiro died in the year 2000, correct? And so,
Yes,
and there were 3
1999.
tenancies post that, I believe, or at least some evidence that there were 3 tenancies post that, which would have allowed 17% to 20% increases in the rent. And plus the IAS that possibly could have amounted to about $561. Aren't there facts tending to show, I'm not saying they do show, but possibly show that luxury decontrol would have applied?
The apartment was decontrolled in 1999. It does not matter what a landlord may have spent thereafter. It is
Sir,
what was
doesn't-
done at the time to justify the deregulation and the removal from DHCR registration. And the landlord had 2 summary judgment motions which were adjourned to permit him to produce everything he could. The landlord clearly understood and never disputed that it was his burden to prove that the apartment was deregulated properly. But it doesn't matter what happened 5 or 10 or 15 years later. The point was that once the apartment was removed from deregulation, there's a presumption of
Was it
fraud.
removed from deregulation or simply not registered after the year 2000?
I missed your question, Your Honor, I'm sorry.
There was no registration after 1999, you said?
That is correct.
Okay, does that mean, is that the equivalent of deregulation?
When the next tenant after Shapiro, who was paying $11.50, the next tenant paid $4,400 and was not notified as to the basis for the deregulation of the apartment, which is an obligation of the landlord to the first deregulated tenant. There's a presumption of fraud that obtains here. And the landlord, despite all the opportunity to do so, simply did not.
Why is there a presumption of fraud? You have an increase in rent and a failure to register. That's the 2 main factors you're putting forth. Why does that bring us into that field of presumption of fraud by itself?
Why does it, I beg your pardon?
Bring us to presumption of fraud. You just said the presumption of fraud applies. Why does a presumption of fraud apply when the only two factors you're really supporting the presumption of fraud is an increase in rent and a failure to register? Why is that by itself sufficient to create a presumption of fraud?
Because there are cases which say so.
What cases say that? What cases say that those 2 factors alone, without other factors,
They
are
create a
sufficient?
presumption. They are not conclusive.
No, but my question is, what cases say that those 2 factors alone are sufficient to create a presumption of fraud? Without other factors being included.
What has to be proven is some basis for doing it.
Counsel, I'm asking you for, if you don't know it, you can say that, but I'm asking you for a case site that supports the legal proposition that you're arguing.
There's the matter of Grimm,
But that doesn't say that.
15 New York 3rd, 358.
I don't
There's
think that
Altshuler
says.
against Jobman. There's Bradbury against 342 West 30th Street. Those are,
So So, counsel, in matter of Grimm, there was more. And I think what my colleague is getting at is that in all of the cases that come from this department as well as from the Court of Appeals, there has to be more. So I think in matter of Grimm, there was an objective, clear misrepresentation, if I'm not mistaken, by the landlord. I don't remember if I said on Grimm or not, but I believe that there was a objective misrepresentation in addition to the 2 other factors that you mentioned.
there has to be more, and it is the landlord's burden to produce more.
Isn't it the tenant's
That was never
burden?
in question here.
Isn't it the tenant's burden to establish that a presumption of fraud applies? You're saying it's a landlord's burden to show lack of fraud?
It is the presumption arises because of the abrupt deregulation of the apartment and the refusal thereafter, the non-registration thereafter, and
Counsel, as my colleague just did, I don't think any of the cases actually say that those 2 factors alone are enough to create a presumption of fraud without something more.
I believe that those factors oblige the landlord to produce some evidence to show that the deregulation was proper. And the landlord here had years of discovery from anyone, prior owners, and anyone that might have been able to shed some light on how this was done. And it didn't happen. the landlord did not produce what needed to be produced, despite ample opportunity to do so. You cannot, it seems to me, as a matter of public policy, place the burden on the tenant to disprove this. It is the burden on the landlord.
But that's not what you're doing. The burden is on the tenant to prove fraud. So what you're saying is, if you can show that there was an increase in rent and a failure to register with DHCR, and that is the showing made by the tenants, and somehow that flips to the landlord, and now the burden is placed on the landlord to show that those two factors did not constitute fraud.
The burden is on the landlord to demonstrate expenses, IAIs, and anything else to show that the apartment was properly deregulated at the time it was deregulated in 1999.
I'm sorry, counsel, I'm sorry to interrupt, but in this case, the landlord argues that they're entitled to various vacancy increases, longevity increases, and as my colleague pointed out, maybe the IAIs. Why isn't that sufficient to raise an issue of fact on your motion for summary judgment to go to trial where in fact the landlord does have to prove what you're suggesting has to be proved?
But he had to prove it. He had two opportunities to prove it. And he had all the evidence that he could possibly gather.
Again, IAIs, the various statutory increases, why isn't that sufficient in itself to raise an issue of fact?
There were issues of fact on the first summary judgment motion, where the court allowed 6 months to do discovery. At some point, the landlord has got to produce what he's got, and either it suffices or it doesn't. And here it didn't suffice. It wasn't shown that the apartment was properly deregulated in 1999. And that's it. That's the end of it. You can't go on, if it was deregulated 5 years later, because there were expenses at that time, that's one thing. But that's not what we have here. We have to go back regardless of the amount of time that has passed. And that's another important issue here. There's no statute of limitations on the status of a rent-stabilized apartment. It would violate public policy. Landlords would be encouraged to not disclose the fact of a deregulation, and if they did it for 4 years or 6 years or however long it would be, then the place would be permanently deregulated.
Thank you, counsel.
That can't be the law. Thank you.
Hold on, sir.
So, counsel, just to your adversary's last point, he seems to be arguing that you had more than sufficient time to produce documents, et cetera, to rebut this presumption of fraud.
Yes, Your Honor. May it please the court, Vladimir Pavlukas for respondent. We do not believe that there exists a presumption of fraud that would require a landlord to produce records from more than 2 decades ago. The burden is on the proponent of the fraud to allege sufficiently that fraud occurred. There are very specific elements to fraud, to alleging fraud, and those elements are inherently factually based.
So in this case, the claim is that there was an unexplained failure to register the apartment around 2000, and that there was a substantial rent increase. Isn't that sufficient for the purpose of the motion to make out a prima facie, which you then have to rebut? And how have you rebutted that?
So we would not agree that that is sufficient, Your Honor. First and foremost, in 2000, DHCR had issued an opinion letter stating that exit registrations were not required. They were encouraged but not required. An exit registration effectively advises DHCR that an apartment has been deregulated. It does not actually cause the deregulation. The deregulation occurs by operation of law. As to whether or not we've sufficiently shown that there are questions of fact as to whether or not the apartment was properly deregulated in 2000, we've stated—
Well, what is your position with respect to the the 2000 occurrence. What happened?
Sure.
Was it a
There was
deregulation?
of
or
course.
just- what was
No,
it?
what happened, and this was 3 owners ago and 20-plus years ago, but what it appears happened based on publicly available records was that the apartment was occupied by a tenant from, I believe, 1972 or 1975, who passed away, and the apartment was then renovated. The renovations, just based on the formula at the time, would have required to be approximately $16,000 to $18,000. So when a tenant who resides in an apartment for 25 or 30 years passes away, it is reasonable to assume that the apartment would be then renovated.
Okay,
This is a
so,
question
so
of
that,
fact.
let's assume for argument's sake, there was some renovations, right? So there were IAIs generated. What vacancy longevity increases around that time would you be
The
entitled
vacant,
to?
so that it's all subject to statute and formula. So the vacancy increase at the time would have been, I believe, 18%, and the longevity would have been 0.6 or 0.6% multiplied by the number of years that the prior tenant resided in the apartment. That
So
would have
where
brought
would
you
that
to about
take you?
another 10%.
In terms of the amounts of the rents, where would that take you?
That alone would, I think, and I believe it's in the record, but based on memory, I think it would have brought you to about $1,500 to $1,600, which then, again, simply math, $2,000 minus $1,500 to $1,600 multiplied by 40, that brings you to about $16,000 to $18,000 in apartment renovations.
So wouldn't the issue of fact have been to address whether the IAIs, assuming you were able to document it to about $16,000, $18,000, or $20,000 to cover that gap?
That's precisely it, Your Honor.
I understand, and you submitted whatever you submitted in opposition, but what the court below said was, right now, I'm not in a position to determine whether a particular IAI, or I's, which were proven to value $20,000, that would bridge that gap.
That's right.
Is a real IAI or a repair. So that could be an issue of fact, right?
That's absolutely correct. And in fact, the Court of Appeals in Gemrock Realty versus Krugman specifically stated that factual issues as to whether or not a landlord's expenditures were sufficient are factual inquiries.
Right.
They can,
And contrary to what I think Mr. Altman was saying, in 2000 or 1999, when Mr. Shapiro, when the tenant Shapiro died, you weren't relying on the 1,100 and change, which was the legal regulated rent then. Your predecessor would have had the right to bridge the gap.
on a formula.
By the formula, and in fact, the Altman decision makes clear you had that right.
That's precisely it. Mr. Altman's decision, the namesake decision that Mr. Altman was involved in, absolutely makes that clear.
So as my colleague pointed out, there's really no, right now, presumption of fraud. It's just a question of determining the legality of the legal regulated rent.
That's absolutely correct. We do not believe that there is a presumption of fraud. In fact, we believe that the Regina decision made that clear. Fraud is a factual inquiry involving scienter, willful misrepresentation, willful and knowing misrepresentation, reliance, et cetera. Regina court cautioned. This court then, I believe, affirmed in Rossman versus Windermere that Regina stated nothing short of fraud warrants the application of the default formula, which is really, that's where the bread is buttered here, I think. I'm not sure if that's the correct phrase. What appellants want to do is, on summary judgment, before trial, have the lower court determine that fraud occurred without an actual, claiming that there's no issues of fact to be in dispute. Once the lower court determines that fraud occurred, I would assume that the appellants will argue that the default formula must be used to establish their rent. That is what the Regina court specifically said, cautioned against. This is the ultimate punitive measure, only reserved in times when the owner is determined to have engaged in a fraudulent scheme to deregulate an apartment, knowingly mislead, misrepresent future tenants, and keep that apartment out of rent stabilization, knowingly, willfully, et cetera. This is not the case here, Your Honors.
Thank you.
First of all, the landlord had 2 opportunities on 2 summary judgment motions after whatever discovery it wanted from itself and its predecessors to show the numbers, show that the numbers, the appropriate formulas the percentages and all the rest of it, the vacancy increases and all of that, brought it over the then legal threshold for deregulation in 1999. I don't recall what it was, but it was probably around $2,000. I may be incorrect, but whatever it was, they had to show the calculations. It is not, and they didn't. And they didn't.
But again,
we could have said we have
Mr.
proof
Altman,
that we spent X, Y, and Z. And the percentages, if we applied the applicable percentages, the rent increase plus a long-term vacancy increase, we would be entitled to X dollars. It never did that. It is not enough to say repairs must have been done, this must have happened, somebody must have done something to bring this over the threshold. No, it's the landlord's burden. It was never disputed, and it is the law.
but the question is, again, I guess, at least in my mind, is have issues of fact been raised based on the arguments that there may be IAIs? Trial court didn't rule on the legitimacy of the IAIs versus repairs and the various statutory increases. Isn't that sufficient to go to trial on this record?
But all the evidence is in front of the lower court. All the evidence is in the record. What else is going to be produced? Are people going to come forward and say, yes, we spent that money? People are going to certify.
Well, isn't that what trials are for? Isn't that why we have a trial for there to be a determination with respect to IAIs? I mean, I've sat here and I've seen those trials and adjudicated them, right?
Well, but the evidence is already here. The landlord had the burden to show that it was enough, and it wasn't shown that it was enough. To send it back is simply going to create the same record that we already have, which is this was spent, we think we spent this much, we must have spent some more, and the result is going to be the same. So there's nothing, I think, to try here. The evidence is clear. It wasn't demonstrated that 1999, the expenses were sufficient to put it over the threshold. And that's why the decision should be reversed and we should be granted the appropriate amount of overcharge and a declaration of rent stabilized status. Thank you very much, Your Honors.
Thank you. Thank you both. Serving Haas versus the City of New York. Yes, counsel, you may proceed.
Thank you, Your Honors. Good afternoon. May it please the court, my name is Christopher Cafaro. I represent Tufco Inc. We moved for summary judgment. Judge Ramser, following oral argument in October of last year, granted summary judgment and laid out the reasons in a very succinct two-page decision. The court starts with the proposition that I, as the movant, had a very heavy burden, which was met by the detailed affidavit by the chief executive officer on behalf of Tufco, who established that all of the work that was done at this location was interior and exterior facade, nothing to do with the sidewalk, none of the permits related to any work having to do with the sidewalk, none of the contracts, and we were just a subcontractor on this job with limited scope of work, had anything to do with the sidewalk. I served upon my adversaries in accordance with 4511C, the Google Map images that are essentially a mirror image years before Tufco even stepped foot on this job site. The same unlevel sidewalk condition existed on that southeast corner. The judge addressed each of the plaintiff's contentions. This is a regurgitation of the motion and the opposition submitted below, which was pro forma, stating that, basically allow me discovery. Judge Ramser set forth saying the mere hope, speculation that discovery might lead to evidence is not enough. All you have offered here is speculations that you might have touched at the sidewalk. I think the definitive and really what makes this an unequivocal granting of summary judgment that should be affirmed in all respects is the fact that if you look at the Google Map images long before, which are set forth and compare it. They start on page 254 of the record and compare it with the circle of the photograph made by the plaintiff of the accident location. It's the same exact condition. That's on 301. If you look at plaintiff's defective sidewalk condition and the Google Maps that were served pursuant to 4511C, it's the exact same condition. Nothing to do with the sidewalk. The decision in all respects respectfully should be affirmed. I submit this is a ill-conceived, at the very least ill-conceived, if not frivolous, appeal. Unless you have any questions, I'm done with my argument. I appreciate your time and effort and consideration. Thank you. Pleasure.
Ware versus Montefiore?
Your Honor, unless you have any questions, we'll submit.
Nope, submitted. Thank you. Yocum versus U.S. Tennis Association?
First time I've taken it off in 3 years in this court.
I hope you've taken it off before that.
May it please the court, my name is Scott Singer, and I represent the plaintiff appellant in this action. As the court is probably aware, it's been raining all day on the Arthur Ashe Stadium today. And I think it'll give you a...
Well, the matches weren't canceled, were they? They could put the roof on.
Well, they got the roof, but from what I'm told, the roof actually leaks a bit. So,
Really?
So depending on where you're sitting. But,
Well, it's never leaked on me, thank you.
Anyway, I say that because I think it give us a feel of what it was like on that day 6 years ago, a little more than 6 years ago, when plaintiff and his coworkers were up on the retractable portion of the roof. It had been raining more or less all day intermittently. It was wet, it was slippery, it was dangerous. And they were all given, they had harnesses and they had lanyards that were 6 feet long. But according to Joel Wuzo, plaintiff's coworker, and his testimony was undisputed, the nearest tie-off point, the anchorage point, was 25 feet away. So a 6-foot lanyard is no good to workers when the anchorage point is 25 feet away. And in fact,
Counsel, your opponent points out that the plaintiff wore his harness that day, and he'd been on the job for a week, correct?
That's correct, but it was...
So the inference that they try to draw is that, well, he wore the harness. Why would he even bother wearing the harness if he knew there were no tie-offs? So would you respond to that?
I think it depended on the precise part of the retractable roof where he was working. And there were some locations, obviously, there clearly was a tie-off system there. It just wasn't at a place where they could use it because they were pretty much in the middle of that retractable area. The tie-off point, the closest one, was apparently in the very center of of that roof, and it was inaccessible to them. And they put in a lot of testimony. They put in the argument, well, we were using a state-of-the-art system, and it was a great system, and it was wonderful, and there were lots of tie-off points. But nobody has said, who was there on the day, nobody has said that there was actually a tie-off point that those workers could have used. So I don't think there's a lot of generalizations and conclusory statements. There's no actual dispute that their harnesses were not usable. So I hope I answered your question, Justice Mullin.
So you're arguing that basically the defendants have come forth with a description of the design, not whether the design was properly implemented or not.
Did they come forth?
I'm sorry, the mask. In other words, you're saying that the defendants came forth with proof of the design of the various tie-off places, but not whether that design was actually implemented.
Right, implemented, and this was not really with the part of the roof that they were thinking. I think the design, was not really dealing with that retractable portion. It was on the permanent portions of the roof, as far as I know, the anchorage points. So,
Are there horizontal lines? I thought there were horizontal lines, at least that's what the defendants point to. There's an installation agreement. It appears to be that there is some line up there, no?
There were lines, but...
Isn't that sufficient to raise an issue of fact with respect to what the the installation agreement says is an acknowledgement of a horizontal line?
I don't know that there wasn't a horizontal line that they could have used at that point where they were working on the retractable portion of the roof. I don't think there was any, I don't even think it was in the design. Apparently they put them up later, but they were not at the time. And I think that testimony was undisputed. I want to deal with, if I may, with the 241.6, because I think that's a very strong point. You know, there is no question, they don't argue that 241.6 was violated because there was the slippery surface regulation, 23.1.7D, says you're not supposed to have your workers work on a slippery surface that's wet or whatever. And there was no dispute it was violated. So the cases of this court and also the Second Department are very clear. If you can show prima facie that there was a violation of the regulation, this particular regulation, 23.1.7D, then that's what you have to show to establish prima facie that you're entitled to a summary judgment under 241.6. And they haven't refuted it. That's the standard. The case of Reynoso and Ortega in the First Department, there's also some cases in this department that I've cited. That's how we made out our prima facie case. They didn't refute it. I don't think there's any question of comparative negligence, but if there was, under Rodriguez, that gets deferred for the jury to decide, and we're still entitled to summary judgment. So for those reasons, we believe that we're entitled to summary judgment under 240 sub 1 and also under 241.6.
Thank you,
Your Honors.
I don't think the mic is tall enough for you.
Can you hear me now?
Yes.
Fred McRoberts, Your Honors, on behalf of the respondents. I think the main issue here is whether or not the proper protection was afforded to the individual worker and its defense position that it has. The system that was created was for a permanent section of the roof. It's a fixed section of the roof, all right? Now, this horizontal structure, this horizontal lifeline structure went around the perimeter of the fixed roof. To reach the individual locations off of that structure, they use vertical lifelines, which attach to the horizontal lifelines, and then the worker will then go down to the location where he has to work.
So what is the concrete evidence in this record that there actually was a place for this plaintiff to tie off on the day of the accident? I know there's a lot of general description about the system, but who with personal knowledge actually testified, yes, there was something available, and this plaintiff had an opportunity to tie off and declined to do so, that it was there?
Yes, Your Honor. First, there's not a general description. I go into very specific detail as to what this system is. Now, you have the horizontal lifeline system, which was at the top of the pitch of the roof. Then David Moffitt actually wrote in his affirmation that to reach the location, the workers were given vertical lifelines to attach the horizontal system and then to go down to the actual location they need to work at. That then, plaintiff never refuted that affidavit. They never called them in.
Doesn't Moffitt
He didn't sign the affidavit or the acknowledgement, Moffitt? I thought that there was an issue in terms of the authentication of his signature on the affidavit.
No issue raised as to the authentication of the signature, as to the authentication of the document. This was the superintendent.
Is this the installation acknowledgement?
No, this is the affidavit that's provided by the superintendent for Bird Air, who is plaintiff's supervisor, who indicated to reach the relevant location that plaintiff had to work at, we provided vertical lifelines, which would therein attach to the horizontal lifeline or single anchor point.
Moffitt wasn't on site when the accident happened, so there's no testimony from him. I was there that day, I saw the lifeline, it was present, and it was available. Isn't that correct?
That seems like a credibility determination.
No, but he
said that individual lifelines were provided on site at all times. He indicated that this system was created to provide protection to the workers. If there's an issue as to whether or not he's correct or not, whether or not those lifelines, that's a credibility determination before a jury. I presented evidence saying vertical lifelines were provided. It's now on, that's an issue then for the jury to decide, were vertical lifelines provided? Was nothing provided, only the 6-foot harness, as plaintiff says. I mean, I think there's a clear issue of fact here.
Counsel, I don't think he states where the lifelines were actually, where they were at the time, whether they were present and where they were present at the time of the plaintiff's fall.
Based upon Bianco Netto, I only have to show availability. That availability was prevented through the affidavit. Now, if plaintiff wanted to get into, oh, where were they available on the site? How did you get to them? Those are all credibility determinations.
Why is that a credibility determination? Where, if he's in the middle and the tie-off is further than where the landlord, the what is it, the grab-and-go lanyards or something are, isn't that an issue?
No, because he says that the lanyard wasn't far enough. So he makes the determination that there was a lanyard provided with 6 feet off the lanyard, okay? Now, to get to that horizontal lifeline, he could attach the line but he couldn't get to the spot where he was working. We presented evidence through Moffitt's affidavit saying, no, we provided vertical lines. Now, those vertical lines attach to the horizontal lifeline and go down to the location, and then you attach to that.
The other thing was there anything in the record that the plaintiff was trained as to how to use all of this, how to use this equipment?
Yeah, we provided the daily task plan that says you have to use the available fall protection. We provided the safety agreement, which was when he first got to the site, saying that if he fails to use the fall protection.
No, but that he was trained how to use the grab-and-go lanyard and how to tie off hair if he's working over there.
That was all provided in the orientation. That was provided in the original safety agreement. This is an individual whose sole job is to work and install roofs around the country. This is an international company that installs roofs all over the world. And this is not an individual who has no idea how to use this.
If you could just address your adversary's point concerning the rain and the moisture and working on a slippery surface.
I think for the most part, the reading and understanding 241.6 has drastically changed recently. It's kind of got to the point where if you show a violation of industrial code, that means that summary judgment should be awarded. That has not been technically the way 241.6 has read. 241.6 is an industrial code created by the Department of Labor, a commissioner. It is not a statute. And when you have...
It's certainly some evidence of negligence, right?
That's exactly what it is. It's some evidence of negligence.
Well, then how have you rebutted their claims of negligence by saying...
At that point, you get into whether or not the subcontractor, whether or not they acted reasonably. Even if you look at the pattern jury instruction, it states, all right, even if you can find evidence of a violation, you still must determine whether or not the subcontractor acted reasonably. Here,
well, would it be reasonable to allow workers on a dome, working on a dome roof without proper safety equipment?
But that's the disagreement. We say we did provide safety equipment. We provided the horizontal lifelines with the vertical lifelines off of it, and that if they had utilized those systems, then he would not have fallen, and he would not have fallen off the roof. So I think a reasonable jury could say, okay, he was out there on the surface, but they provided these protections. We can find that the subcontractor acted reasonably.
Thank you.
Thank you.
Your Honor, there was no proof that...
Let me just ask a question. What is your response to the specific argument that Moffitt did adequately testify, at least to raise an issue of fact, that there were sufficient safety devices available that he could have used and that would have reached down to even where he was on the roof?
I respond to that by citing the Gallagher against New York Post case. It's not enough to say that there's equipment available somewhere. You have to be instructed, the workers have to be instructed how to use it, and they have to know where the necessary equipment is, where it's being kept.
Well, your adversary said, I'm sorry.
Aren't they alleging that that was the case, that there was training and that the equipment was generally available? I mean, don't they have testimony to that effect in their papers?
There's no testimony directed to the use of these temporary lifeline systems. They were instructed on that. And there's still no evidence as to where the necessary equipment was kept, or that the workers were ever instructed particularly about that type of.
Well, that's where your adversary stated that there was orientation, there was various materials given to the workers, also that your client was, he knew how to use the equipment, you know, this was something that he did as his career.
I think that that's what Gallagher stands for, the proposition. They have to come up with proof.
Well, what about the orientation and the manuals that he states that they received when they first came on the job?
I don't believe that they've pointed to any evidence this specific contingency was addressed in those manuals.
Contingency meaning the slippery...
The slippery system, and to rig it in such a way in that particular circumstance when they were on the retractable portion of the roof. I haven't seen it.
Counsel, also, HiSafe's training certificate. Who was the person who was trained by HiSafe? HiSafe trained one person from Bird Air, right? Who was that person? It was Moffett. Was there anybody else trained as far as you put this in your paper?
Not as far as I know. And as you know, Moffett was in Hawaii when he signed the statement, and he admitted that he did not know the configuration or the status at the time of the accident. So I don't think his testimony is very helpful.
Thank you.
As far as the
Your time is up, but thank you so much.
Thank you very much.
Peldman versus Kalari Resorts. Ready.
Good afternoon. May it please the court. Renee DeMott for the respondent defendants. I just wanted to briefly go over my arguments from my respondent's brief. As the court well knows, jurisdiction is one of the basic questions in whether or not a case can proceed. And in this case, there was no showing as to differentiate this case at bar between from the case of Stern versus 4 Points, which very clearly stated that in the case of a situation that arises at an out-of-state hotel, there is no jurisdiction unless there's some connection to the state other than websites or things like that. And on this appeal, the plaintiff has failed to show that there was any difference between the parties in Stern and the parties in this case. Also, there was also the issue that they did not submit any evidence in rebuttal to this motion. They only submitted the complaint and the amended complaint. There was no basis for no evidentiary basis for an argument that there was jurisdiction over these defendants.
Well, they participated in the Thanksgiving Day parade, right?
They did, Your Honor, but that still doesn't.
That wasn't enough to establish jurisdiction?
No, Your Honor. And like I said in my brief, too, this regulatory scheme has been followed by several courts throughout the state at this point. The federal courts have repeatedly said that this is not a basis for jurisdiction. Second Department has said this is not a basis for jurisdiction over an out-of-state hotel. And this is
how about A3? Could you argue that the injury occurred in New York?
Yes, the site of the injury was actually in Pennsylvania where this occurred.
I'm asking you, could you say that the injury occurred in New York?
I did not say that the injury occurred in New York.
I'm asking you a question.
Could it be argued that the injury occurred in New York?
Thank you.
Sorry. No, Your Honor, because everything that my clients engaged upon occurred in Pennsylvania. They didn't care for any property here in New York or anything like that.
Well, could they not have brought the bed bugs back from Pennsylvania and actually have been bitten in New York?
Well, the defendants did not bring the bed bugs back to New York. The appellant did.
No, I'm saying the bed bugs were in Pennsylvania, right? So could they not have brought the bed bugs to New York and actually have been bitten in New York? Would that establish jurisdiction? Is that enough to show that the injury occurred in New York?
No, it's not, because there was no act by the defendants that would have connected them to New York. The defendants didn't do anything here. They didn't have any agents here, no employees, no.
The bed bugs would have been the agents, but, right? Thank you, counsel.
Your Honor.
Thank you.
You probably get diversity jurisdiction in federal court. You know.
Yeah, exactly. Okay, where are we up to here? Lyons versus, oh, yes, Lyons versus New York City Transit. Wish you wouldn't laugh.
I didn't mean to.
Yes, counsel.
If it pleases the court, my name is Ronald Ramo. I'm here on behalf of Yadgarov and Associates, the attorneys for the appellant, Daniel L. Lyons. The question presented by the appellant is whether or not the court below properly granted summary judgment to the respondents. The appellant argues that the court below did not properly grant summary judgment because, first and foremost, the respondents failed to establish a prima facie case. In the extent
Counsel, I got to disagree with you there. Didn't Dr. Warhead establish via his report that the MRI showed degenerative disease, and then that puts the burden on you to show no, the alleged injury was caused by this particular accident?
To the extent, I would disagree to the extent that the respondents also submitted the MRI reports from the attending radiologist, Dr. Losick, who gave an opinion that the injuries to the lumbar spine and the right knee, as he viewed them in the MRIs, were of a traumatic nature. I would also argue that the contemporaneous range of motion findings from March 28th of 2016, approximately 15 days after the accident, also are quantitative proof of limitations that indicate that the accident caused those limitations.
How is that, counsel? I don't understand how you make that statement. I went through the record and I could not find anything where any expert opined that the injuries or your client's complaints were causally related to the accident. There's nothing in the medical reports, nothing anywhere that states that there's a causal relationship.
Your Honor, there is no explicit report stating that these things were caused by this specific accident. However, Dr.
Right, by this specific accident. So would that not therefore mean that perhaps they were caused by the other two accidents? I think your client was involved in two other accidents, if I'm not mistaken.
Although that may be an interesting point, Your Honor, the fact is Dr. Warheit looked at the 2014 MRI and found a clean back.
Okay, so maybe it wasn't the first accident, maybe it was the second accident.
There was no accident between 2014 and 2016 except...
But again, there's nothing here that says that it was caused by this accident. Don't we need that? Shouldn't that be somewhere in the record?
To the extent that the record only, the plaintiff at this point in time has to only present a sufficient proof to raise an issue of fact, even if it's hardly powerful. And to the extent that Dr. Losick is of the opinion that the injuries he observed in the MRI films were of traumatic nature, it can be inferred, since the plaintiff is not the movement on this motion, that they were caused by this accident, especially since Dr. Warheit indicated that the 2014 MRI showed no trauma to the lower back.
Plaintiff is not the movement, but plaintiff also has to come forth with something to rebut. And I also found it interesting, I believe this is the case, you relied only on the defendant's medical experts. You didn't present any experts on your own, that any plaintiff's physicians, any physicians that plaintiff had gone to.
Your Honor, first and foremost, to the extent that the defendant doesn't establish a prima facie case, the plaintiff has no, the non-moving party doesn't have a burden to present its proof. But to the extent that Dr. Levitt's report is so egregiously showing limitations and is of the opinion that the cervical, thoracic, and lumbar injuries are unresolved, that itself it would be enough to show limitation.
How about counsel, Didn't you have a radiologist who opined in April 2016 that in fact that there was disc desiccation in this case? So in fact that it wasn't traumatically induced, right?
That may have been with respect to the cervical spine, Your Honor. However, with respect to the lumbar spine, he is of the opinion there is evidence of trauma in that there is fluid in the facet joints, and he says that is evidence of trauma. In addition, with respect to the right knee, he says that the effusion is of a traumatic nature.
Counsel, doesn't Dr. Levitt opine that whereas some of the symptoms are unresolved, he found the plaintiff to have exhibited symptom magnification?
Your Honor, he says that it's suboptimal, but that's not clear as to what that means, because it's not indicating that the plaintiff, the party, is malingering or otherwise engaged in self-imposed limitations.
Didn't he also find that the plaintiff was capable of performing all the tasks of daily living independently?
Well, however, he finds that these are unresolved sprains with limits in range of motion, and it's our contention that this could either be a permanent consequential limitation or significant limitation of a body member or organ that warrants this going to the trier of fact.
But Dr. Levitt also examined the plaintiff 3 years after the accident, right?
That is correct, Your Honor.
Thank you.
Good afternoon, Your Honors. Harriet Wong from the MTA New York City Law Department on behalf of defendants' respondents. Your Honors are correct. The most significant flaw in plaintiff's argument is his failure to address causation. Actually, plaintiff was involved in 3 accidents. According to his EBT testimony, he was involved in an accident when he was about 10 or 11 years old in 1999. He was involved in an accident in 2013 where he treated his lumbar back for approximately 2 years and was hospitalized as a result of that accident. And then he was involved in a 3rd accident 2 months before the subject accident where he was operating a U-Haul, and he unfortunately did not provide any information about the injuries he sustained there. So yes, maybe Dr. Levitt may have opined that he has some lingering strains and sprains in his spine. However, that does not relate to anything, that does not causally relate any of these sprains or strains to the subject accident. Further, plaintiff keeps talking about the MRI of the lumbar spine from April 2016. However, the specific diagnosis was that there's fluid in the facet joints that must be correlated clinically, and it was only deemed to be a possible setting for flexon/hypertension injury or other trauma.
So why then does this not raise an issue of fact as to whether his condition is causally related to the subject accident as argued by your adversary?
Because according to this record, that was never correlated clinically. And plaintiff's MRI from 2014, 2 years before the subject accident, actually shows that he already has bulging discs at the same exact 3 segments of his lumbar spine. Plaintiff does not dispute this, and in fact, plaintiff's BP at page 35 actually alleges supposed exacerbation of these same segments because they recognize that he had bulges at the same exact segments of his lumbar spine. Nor does plaintiff try to bring up anything about his x-rays that were taken about 2 weeks after the accident that actually show congenital problems with his spine. Dextroscoliosis, immediately followed by levoscoliosis, if I'm pronouncing that correctly, which could be another correlation on why he has bulges and or degeneration to his lumbar spine. Plaintiff also relies heavily in discussing his medical record from AC Medical from March 28, 2016. However, that medical record mentions nothing about causation, and actually the sections concerning any alleged restrictions that the plaintiff should apply or any medical necessities for future treatment are actually left blank. Then, of course, we bring it all back to plaintiff's testimony at his statutory hearing and EBT, what are the subjective complaints that he has. He stated 4 months after the accident at his statutory hearing that his back and neck were not bad. The only thing that he felt at the time was some pain in his right knee. The objective medical test concerning his right knee actually showed that he had a possible malignant lesion in June of 2016, around the same time of his statutory hearing. Then at his EBT, he claims the limitations he has as a result of this accident is that he can't play basketball or has a hard time playing basketball. He has a, pain when he drives long distances, and he can't sit for extremely long without feeling pain between his neckline. However, plaintiff just conceded right now that the MRIs of plaintiff's cervical spine show desiccation of the discs, which is non-traumatic in nature. So the defendant's motion for summary judgment established their prima facie case, and plaintiff's submission of the single IME report of Dr. Levitt did not cause or show any triable questions of fact. If your honors do not have any further questions, I will submit on the brief.
Thank you very much.
Thank you so much.
If it pleases the court, I just want to address specifically the fact pointed out by the Respondent's Counsel concerning the accident that happened involving a U-Haul approximately 2 months prior to this accident. It must be indicated and emphasized that the plaintiff stated under oath he was not injured in that accident, he did not seek any medical treatment for that accident. And it must be taken into account that the respondents had ample time prior to this action being filed for deemed trial ready and certified as such to discover any medical records relating to this accident, which it did not find. Thank you.
Thank you. Thank you both. People v. Fernando Rosario.
Good afternoon, members of the court. My name is Labe Richmond, and I represent Appellate Fernando Rosario. What's really wrong in this case is that, had the defendant had a competent attorney in the first place that even had a rudimentary knowledge of immigration law, he certainly would have gotten a plea to a weight offense that could have saved his life in the United States, and he wouldn't have been mandatorily deportable. I think...
Wasn't the evidence rather strong in this case? There was a consent search of the apartment. Wasn't there pretty strong evidence of the amount of, I'm forgetting how much it was now, 300 grams of cocaine?
Well,
am I mistaken about that?
I'll say two things, Your Honor. Number one, there's loads of cases where the prejudice can simply be that there was an alternative plea that could have saved him. They were offering probation, so all his lawyer had to do was say, oh, this is mandatory deportation, sir. Let's try to get a weight plea. That's prejudice. It doesn't matter how strong the case is, but I will say this as a second point. The officer claimed that he could see him put a twist in someone else's bag. I mean, that seems like there was a good search issue. Everything came down from that. That was incredible. I think he did have a case to try. He had been here for 22 years at that time, and he had his parents, he had his 3 children, he had his sister, he had his brother, he had nieces, nephews, cousins. Why would he take a plea to mandatory deportation? I mean, the issue is, would he have taken...
Because what would he have faced if he did not take the plea, counsel?
Well, if he had gone to trial on the indictment, he could have gotten probation after trial.
Given the amount of drugs that he had?
No, I mean...
is that reasonable? He
had
over 300 grams of cocaine in his
I don't
apartment.
have any argument with that, Your Honor.
But that's one of the issues, is whether he would have, in fact, not taken the plea, but for knowledge of the immigration consequences.
But under Lee, in the United States Supreme Court, the case was overwhelming, and I put in my brief loads of cases where it's overwhelming. I mean, reasonable probability is hard, but I mean, that's not really my point. My point is the alternative plea. Chaco, Pinto, Abdullah, Santos, all these cases where they say, if you're told that it's mandatory, his lawyer didn't even get the right information about his immigration consequence. You know, he said, oh, I belabored that he was a citizen or a legal permanent resident, but I found out he wasn't. Well, he was a legal permanent resident, and the lawyer could have saved him. At the appendix at page 52 and 54 show that he was a legal permanent resident.
Mr.
All
Richmond.
he needed was a wait plea, and he'd be...
Counsel.
I'm sorry.
I'm
the
sorry.
judge has a question.
I'm sorry.
You don't apologize. He should be apologizing.
Yeah, I'm apologizing. Come
Crossover
on.
over here. Mr. Richmond, my understanding on the record is that in September, 2 months before the month, November, that he took the plea, his resident card expired. That's unchallenged on this record, correct? So at the time of the plea, the statement that you made that he was a permanent resident is not accurate.
Yeah, that's wrong, Your Honor. It's kind of like if you're a licensed driver, but you lost your license. You're still a licensed driver. You just don't have the card. So he needs to renew his.
You can't drive a car, correct?
But he's still a licensed driver. Like if you want to get a job, you need to show your green card. So if you don't have it, you need to renew it. But you're still an LPR. You're still a legal permanent resident. I mean, there's no case that the people have presented that show that you can't get cancellation of removal if you know that you're not a legal permanent resident just because you don't have the card. There are many people, by the way, who don't renew their cards for whatever reason. They're still legal permanent residents. They just don't have the card. Like they can't go to a job and say, "Here, I'm a legal permanent resident."
Fair enough. Let's go back. Let's go back to the allocution that took place. And as I read it, the judge was very careful. Where you can argue that perhaps his lawyer was equivocal about deportation, the judge was very clear in telling your client, and again, there was a translator or an interpreter that explained everything. He says, are you aware that there's a real likelihood that you will be deported? And your client said, yes, I understand. And he went through all the different steps, and parenthetically, you never took an appeal. I mean, your predecessor lawyers never took an appeal of the sentencing, nor did you take an appeal of the earlier 440.10 motion, correct?
That's correct, Your Honor.
Okay, so going back to that allocution, even you don't challenge that the judge was very careful in making it very clear to your client, you know, you're going to take this plea of probation, which sounds pretty good because he doesn't have to go to jail for something that, if he went to trial, would likely give him a jail sentence. And he said, you understand, you had a chance to talk to your lawyer, and it goes through all the different steps during that allocution. You don't really challenge that your client didn't understand what was told to him by the judge, do you?
Well, in his affidavit, he did say that he was nervous at the time, and all the case law says that it's a Sixth Amendment right to have the attorney do. In fact, in Peque, it said this is essential for the attorney to investigate his client and give specific advice prior to the plea. And here, the attorney had the wrong information, and also the judge didn't say mandatory deportation. He said there's a likelihood, but that's right after the attorney said there's just a risk of deportation. Now, the reason...
So, counsel, I'm confused because I think you're mixing up the proceedings. From what I read of the record, what Justice Shulman was just referring to was the allocution. He went through the allocution. He spoke to him concerning the immigration consequences, etc. He said he understood everything. Now you're saying he was nervous, which, you know, do you understand? Yes, and this is what you want to do. Yes, I don't see what nervousness has to do with it, but fine. So I'm not really understanding, you're appealing the denial of the 440. So again, on this appeal, the issue is whether or not he was advised of his rights, the knowledge as to the deportation, and also you have to show now that he would not have taken the plea but for the information imparted to him as to his immigration status. And I don't see that you're addressing those issues.
Well, Your Honor, the point about the judge taking it over and basically correcting the attorney, that's a Fifth Amendment issue, but the Sixth Amendment issue is that the attorney should talk to the client at a time when he can plea bargain and tell him this is mandatory deportation, but we can try to plea bargain it out, and there's a reasonable probability he would have gotten the weight plea. That's the key to this.
I thought there was a plea bargain. There was not a conviction after trial, was it? Didn't he plead guilty?
He pled guilty to the top count, but he could have negotiated for a plea just like in Chaco.
He pled guilty to the sale, and he received 5 years probation. So although he pled guilty to the top count, he still got the 5 years probation. If he had not pled guilty to that and he had gone to trial, what was his exposure?
But what we're saying is that he could have arranged for a weight plea instead of a sale plea.
And how do we know he did not?
Because there's no record that anyone ever asked, and he signed an affidavit that he was never given that option.
Signed the affidavit, meaning the defendant signed the affidavit.
Right, but it's...
Did we get was there an affidavit from the attorney? I don't know, Mr. Gutline, I don't know when he passed, but was there an affidavit?
It was Mr. Marley.
Okay,
and we asked him, we asked him to contact us, and he never did. But we did try.
We don't know. There's nothing in the record that there was no discussion between the defendant and his attorney and the people for a lesser plea. We don't know whether that occurred or not. And your argument that there should have been this discussion is pure speculation because we don't know that there wasn't this discussion. Is that correct?
Well, it's not pure speculation, Your Honor. It's
okay, it wasn't pure, but we don't know, basically. The record is silent.
Well, the defendant says he was never given that option. I mean, all we're asking for is a hearing. The people agreed to vacate and give him that alternative plea after I filed the motion. And the judge then just rejected it and wouldn't even speak to us about it and issued a decision that he wasn't going to consider the second motion, and he said it was procedurally barred. That's wrong. So if the people gave it to us as a result of the motion, they certainly would have given it pre-trial. I mean, here they were giving probation. All he had to do was say, it's give him the C felony or we'll do a new felony complaint or whatever. Give him the weight. He's been here for 22 years. He has his whole family here. Why wouldn't that have happened?
Thank you, counsel. You have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Jeannie Campbell-Urban for the people. I just first want to clarify, if I may, the procedural posture of this appeal. The defendant pled guilty to third-degree sale. He received probation.
And that was the top count?
That was the top count of the indictment, yes. George Gutline, who Your Honor mentioned, filed a 440 motion in 2015, I believe, alleging that Mr. Marley, the trial attorney, had not accurately advised the defendant of the immigration consequences of his guilty plea, and that the defendant was prejudiced by that misadvice. We opposed that motion, essentially arguing that the defendant didn't meet his burden on either prong, and Justice Burke denied the motion, saying that there was no indication the defendant had been misadvised by his lawyer, that the defendant's statements at the plea colloquy contradicted the information in his 440 motion, and that the defendant had not established that he would have rejected the third-degree sale plea, even hypothetically, even if hypothetically he had been misadvised.
And one of these proceedings had been adjourned, right, so that the defendant could consult with an immigration attorney?
That's correct. When it was, I believe, Justice Stoles who took the plea, and when he began the colloquy that day, he said that the case had been adjourned for the explicit reason for the defendant and Marley to consult with an immigration lawyer or otherwise address the immigration issue. In response to that prompting by the court, Mr. Marley said that he had discussed the risk of deportation with defendant. The court then said that there was a real likelihood of deportation. The defendant said that he understood that. Under those circumstances, and again, as Your Honor pointed out, it was a strong case where the defendant, his conviction at trial was a virtual certainty, I would say. Justice Burke correctly determined that the defendant did not meet his burden to establish either that he had been misadvised of the immigration consequences of his plea or that he had been prejudiced. But again, I just want to point out that that was the first 440 decision. There was then, Mr. Richmond filed a second 440 motion raising what we argue are identical claims to the first 440 motion, and Justice Burke denied that motion as well. As we said in our brief, it's our position that the first 440 motion was correctly decided, and for that and the other reasons in our brief, Justice Burke did not abuse his discretion in denying the second 440 motion.
Didn't you argue in opposition that the potential for a weight plea really is problematic based on our own precedent? You cited the Acosta case, that it would not have made it, it would not have been deemed a lesser included offense. Am I correct?
That's correct, Your Honor. This court's decision in Acosta said that the third-degree weight possession offense was not a lesser pursuant to the statute, was not a lesser included of the third-degree intent to sell offense. So as we pointed out, the weight offense that the defendant has been advocating for most strongly was third-degree weight. But under Acosta, that would be an illegal disposition.
But that's what I did not understand, because your adversary just argued or just stated that at the proceeding, I guess the last proceeding before Justice Burke, the people stated, you stated that you would now offer that weight plea.
It's correct that we, and again, this is outside of the record, I just want to make that clear, but of course I'll answer the question if you would like me to. The people and defendant did agree to vacate the defendant's plea and offer him some sort of weight-based disposition. Mr. Richmond says that that was a third-degree weight-based disposition. I don't have any information that suggests that Mr. Richmond is wrong. But it is true that under this court's decision in Acosta, that plea would have not been jurisdictionally valid because third-degree weight would not have been considered a lesser included offense of the third-degree sale charge. Unless this court has any other questions, I will respectfully ask that you affirm. Thank you.
Your Honors, as to the...
I haven't really heard you address the fact that this is a second 440-10 motion, and that's not necessarily the same standard the court's going to look at it when it's the first. So how does that affect the court's analysis of...
Well, the court has the full authority to consider a second motion for good cause in the interest of justice, or the court...
Because the court explicitly found that it was the same arguments being made on the second motion as the first, why should the court, for good cause, reconsider the same exact arguments, what it found to be the same exact arguments?
Because the people, first of all, had agreed to vacatur and a weight plea, which could have been 22009. It could have been, and by the way, just to answer the question about the plea is illegal, D'Amico, and there's so many ways that this plea could have happened. Just because of Acosta, which happened after this case was decided, it could have easily happened. But it says you may deny the motion because there was a prior one. So the court can just not consider that and just deal with the motion. And the first...
But the court specifically found that it was the same arguments being made. So
but it wasn't the same.
The court's not required to.
It wasn't the same because the affidavit of the defendant here talked about the alternative plea, that he would have taken the plea. That's so different. And the first motion just wasn't done well. Gutline didn't do a good job. If you look at my argument and if you look at the reply brief, you can see that there were many good reasons to consider the second decision. For example, the judge in the first decision, he didn't deal with the alternative plea at all. And the people consented to that in this proceeding. I mean, I don't understand how we cannot go along with that. The people gave in, and the judge said that he was procedurally barred when the statute specifically gives him the discretion to consider the second plea because it says it may be denied and it
But
may
he
be...
said that. See, that's, counsel, that's what I'm just saying. He said that. He said that in his decision. Under 44010, subsection 3B, a court may deny a post-judgment motion when the issue raised was determined on the merits in a previous motion. This is what he said.
But then he didn't follow it. He then said it was procedurally barred and he must deny it. Must. Procedurally barred.
Under the circumstances presented. He said he was denying it based upon the circumstances presented.
Yeah, he did not say that. And
So
I
it
will say
appears that
this.
he was aware of the fact that it's a may, but he's saying that under these circumstances, and the fact that you're making the same exact arguments that you made before, I must deny it.
Well,
That's what it appears that his decision is.
I don't think if he were to say, this is why I'm not going to do it, in fact, he never said interest of justice for good cause shown. He never said that in his decision, and that's a critical omission. He must say that if he's saying the law, but then he says it's procedurally barred without discussing his discretion, without saying why. And there was a difference in the two
Because there was
motions.
no indication that Marley failed to accurately advise the defendant and that the defendant had not defendant did not meet his burden.
But Padilla says that he has to be given the clear and succinct consequences, which is mandatory deportation. And in this case, he was never told that. He wasn't told that by the judge. He wasn't told that by his attorney. In fact, we know he wasn't told that by his attorney because the attorney said risk. I talked to him about the risk of deportation. And had he known it was mandatory, he would have sought the alternative plea, which is legal, 22009, a lesser included offense, not a problem under Acosta. And the people agreed to that in the second motion. And Judge Burke refused to hear us on that issue. And I'm sure he thought that there was something wrong with my motion, but I don't think he read everything. I think
That's speculation. But thank you so much. Thank you both. And we have Jen versus Herman. Whenever you're ready, counsel.
Thank you. Good afternoon, Your Honors, and may it please the Court. Kyle Seiss for defendants appellants Binyan Lorimer, LLC, and Herman Equities, LLC. The decision below should be reversed, and appellant should be dismissed from this action based upon their post-answer 3211A7 motion, which was denied. The court below principally erred by reading two allegations into the complaint that simply aren't there. First, the court below refers to allegations against the quote-unquote moving defendants. Yeah, that's record page 6 that are not in the complaint. And second, the court below relies on a theory of vicarious liability to keep appellants in the case. That's record.
So, counsel, I would agree that this is not the best drawn complaint. However, paragraphs 12, 13, and 14. At all times, defendant Henry Herman operated the aforementioned motor vehicle in the course of employment of defendants. Paragraph 13, at all times mentioned defendants maintained the aforementioned motor vehicle. 14, at all times herein mentioned defendants managed the aforementioned motor vehicle. 15, at all times herein mentioned defendants controlled the aforementioned motor vehicle. So, it appears, as I said, it's not the best drawn complaint, but I mean, it clearly gives the notice that we're talking about Mr. Herman acting under the employment of the two LLCs, one or both of the LLCs.
Your Honor, I have no better response than this own court's language in Aetna Casualty and Surety Company against Merchants Mutual Insurance Company that's cited in the brief. It refers to multiple causes of action, including causes of action not subject to 3016B. And it says, moreover, the first four causes of action are pleaded against all defendants collectively without any specification as to the precise tortious conduct charged to a particular defendant.
Counsel, there are a lot of cases that say that, but those are very cases where there are numerous causes of action, numerous defendants, and without some explanation, it's almost impossible for a defendant to tell what the claim against that defendant is. But this is a pretty simple case. There's no question that to the extent that there's a respondeat superior argument, it's directed towards the LLCs. What other conclusion could we draw from looking at this complaint?
Your Honor, first of all, there's nothing about respondeat superior in the complaint. That was raised by a respondent's brief, and the court below went along with that. I see my time is up. May I continue my answer?
Yes, please.
But if you look at, for instance, page 21 of the record, paragraphs 24 and 25 of the complaint, it says that the relief is due to the negligence of the defendants, and paragraph 25, the action of the defendants.
Counsel, we all know what employer means. The reason an employer would be liable for an employee's actions is based on respondeat superior, whether or not those words are used or not. That's what it means when an employer is held liable.
And it specifically states, Henry Herman operated the aforementioned motor vehicle in the course of employment of defendants.
Right, Your Honor. So first of all, again, back to Aetna, that's group pleading. But second of all, there are elements to respondeat superior. There's furtherance of the employer's aims, there's scope and control. There's plenty of cases about that. And there's really no allegations that would even support that, even if it were paid lip service to. There's allegation of control over the vehicle of all defendants at some time.
Aren't you raising issues that should be raised on summary judgment as opposed to on an A7 motion?
No, Your Honor, because within the four corners of the complaint, there's simply no reference to respondeat superior or allegations.
I don't know. I heard my colleague at least twice make reference to it, so I'm not sure she's reading correctly, but that's what I'm hearing.
She read it very well, Your Honor. And she read it very well, Your Honor. And as she said, it says defendants. That could mean there are four defendants. There's Henry Herman, there's Layahuda Sheriff, which is a religious corporation, and then there's appellants. Defendants could mean any subset of those four defendants. So we're not given the notice to properly defend the case. Also, my time is up. May I conclude very briefly?
No, that's it. Thank you so much, though. We appreciate it.
Thank you for your time, Your Honors. Thank you, sir.